Dear students, today my lecture is on arrest. You must have read in newspapers that so many persons are arrested every day. So what are the procedures behind these arrests? Today we are going to discuss about these procedures. These procedures have been laid down in the Criminal Procedure Code 1973. It has been mentioned under the sections from 41 to 60. So today we are going to see what are the procedures. I have listed out the procedures in several topics. The first one is meaning and purpose of arrest. The second one is the decision to make arrest. The number 3 is what are the offences relating to arrest. Number 4 is arrest with a warrant. And number 5 is arrest without a warrant. Number 6 is how the arrest is made. Number 7 is what are the procedures after the arrest. And the number 8 is what are the rights relevant to the arrested persons. First we will see what is meant by arrest. Arrest means if a person violates any law in existence, then he is detained by legal authority. Only a legal authority can detain any person who violates the law. No other private person for any other reason can detain any other person. So arrest is made by a police officer who has been given power under the Criminal Procedure Code to arrest a person only when he violates a law. Even the police officer has to follow certain procedures before making an arrest. So arrest means detaining a person by legal authority. Arrest can be made to make a person to attend the court. For example, in a case, if a particular person is wanted, then he may be arrested and brought to the court. This will be done under the direction of the court by the police officer. A police officer can arrest any person when that person is not giving his correct name and address. See, for example, a person does not give his name correctly and does not give the correct address. That means he has something wrong in his mind or something wrong in his activities. If a person is a genuine person and he is following the rules and regulations, then he should give the correct name and address to the police officer. So at that time also the police officer can arrest a person. Then again, if a terrorist is going to attack a building or a person or a group of persons, then also the police officer can arrest a person without any warrant itself. It is a preventive measure. It is a precautionary measure. Something is going to happen at that time. As a preventive measure, the police officer can arrest that person. A police officer can also arrest a person when that person obstructs his duty, because a police officer has been empowered to carry out activities under the Criminal Procedure Code. So when he goes to a particular place to carry out his activities or to implement the directions of the court, if some person they are obstructing his functions, then at that time he can arrest that person. A police officer can also arrest a person who has escaped from the lawful custody. See, for example, if a person is punished to undergo 2 years imprisonment and he is undergoing the punishment in the jail. Suppose if he escapes from the jail, then the police officer has the power to arrest him. Then we will see who has the decision to make the arrest. The decision is made by a judicial magistrate. He is the correct authority to issue warrants. What is meant by a warrant? A warrant is a signed order. It is signed by the magistrate. If some offense has happened and if some person has to be arrested, then the judicial magistrate can issue the order. It will be sealed and addressed to a police officer who has been given the power to arrest the persons. The order will command the police officer to arrest the person mentioned in the order. As per the directions of the warrant, the police officer can arrest any person whose name has been mentioned in the order, but he has to produce the arrested person before the magistrate within 24 hours. If not, the police officer has to meet the other directions from the court. Before going into the procedures of arrest, we have to see what are the categories of the offences. There are 6 categories of offences. The number 1 is a cognizable offence. What is meant by a cognizable offence? It is an offence by which a person make another person to death or cause grievous injury. At that time, a police officer or a directed officer can arrest a person without any warrant. Number 2 is non-cognizable offence. Non-cognizable offence means any offence which has been done by any person, but it requires a warrant to arrest. The police officer has to get a warrant from the magistrate and then only he can arrest. Number 3 is bailable offence. What is meant by bailable offence? A bailable offence means for offence there is some punishment. If the punishment is less than 3 years imprisonment, then it is known as the bailable offence. At that time the police officer can arrest a person, but the person who has been arrested can be released on bail from the court. And the fourth one is non-bailable offence. The non-bailable offence means an offence for which the punishment is above 3 years imprisonment. In this offence no person can be released on bail. He cannot be initially released, but on further requisitions his bail may be considered by the court. The fifth one is warrant case. A warrant case means a warrant will be issued for arresting a person. Only with the warrant the police officer can arrest a person. The sixth one is known as summons case. In this case only summons are issued to any person to give any evidence or any witness in the court. Here no arrest will be made. Only the person has to appear before the court and answer the questions before the court. Next we will move on to arrest with a warrant. What are the procedures for arresting a person with a warrant? The warrant will be issued by a magistrate after taking cognizance of an offence. What is meant by cognizance? Cognizance means taking notice or aware of a committed crime. The crime committed should be known by the magistrate. How it can be known by the magistrate? It can be known by the magistrate through police report or the complaint by the complainant or any other information known to the magistrate. Even the magistrate can take suo motu action if he knows that some crime has been committed. If it is a summons case, only summons will be issued to the persons to come and answer before the court. If it is a warrant case, then directly the warrant will be issued to arrest a particular person. Next we will move on to the arrest without a warrant. When an arrest can be made without a warrant? See, all the time the police officer cannot wait for the warrant to be issued by the magistrate. If a terrorist is going to attack a particular place or a particular building or a particular person, at the time the police officer, he cannot wait for getting a warrant from the magistrate. At that time he can arrest that person without the warrant from the court. It must be a cognizable offence, because for committing a death or making a burglary or making a dacoity, we cannot wait for the warrant. If it is a stolen property, then he has to arrest the person and seize the stolen property. If a person is committing a death, at that time he can arrest that person without any warrant, because it happens before his eyes. At that time he cannot wait for any warrant from the magistrate. Not only the police officers have the power to arrest a person under the Criminal Procedure Code. The Criminal Procedure Code has empowered even a private person to arrest any person. When a private person can arrest another private person? When he sees a private person is committing a murder or committing a death, committing an offence against the nation, at that time a private person even can arrest any other person and produce him before the court. Next we will move on to how the arrest is made. In what ways the arrest is made? The number one is power to use the force. While issuing the warrant, the court also gives the power to use the force to arrest a person. So if a police officer goes to arrest a person and he is not available there, he can use any force among the family members or any other persons to make the person arrest. Number two is the power to search a place. So if a police officer goes to arrest a person and if the person is not available, he can search any of his house places or any other places related to him. He can go without any warrant or with a warrant to search the place, because he has to find out the person and produce the body before the court. That is the essential one. So the court gives the power to use the force to search a place. The number three is the power to pursue. What is meant by power to pursue? The police officer, if he needs or if he necessarily wants any evidence or witness, he can take the arrested person to any corner of India. He can take him to anywhere to gather the evidence or to gather the witness against him in the case. The fourth one is the power to obtain assistance. the police officer can obtain assistance from his subordinate officers or any other officers or any other private persons to arrest a person. If a person is absconding, then he can get assistance from any other persons to arrest that person. The fifth one is the power to require a subordinate officer while going to arrest a person. It means the police officer who is engaged to arrest a person, he can request the services of his subordinate officer. For example, if the court orders an SP to arrest a person, then he can request the DSPs working under him to assist him in his duty. He can go as a group, he can avail the responsibilities and the other assistance from his subordinate officers. The last one is the power to arrest a escaped person. A person may be escaped from jail. He is already detained by law and he has been punished under the law. While undergoing the imprisonment, he can escape from the jail. At that time, the police officer has the power to re-arrest the escaped person and submit before the court. Next, we will move on to the procedures after making an arrest. What are the procedures after making an arrest? There are so many procedures. The number one is to search a person. Why to search a person? See, the arrested person can have so many weapons or any other evidences or any other witnesses with him. So the first essential one is to search the person after making an arrest. Then the next one is seizure of the offensive weapons. So the police officer who arrests the person immediately seize the weapons with the arrested person. He has to remove all the weapons from the arrested person. The number 3 is the medical examination of the arrested person. Why the medical examination to be conducted on the arrested persons? For example, you take the rape case. In the rape case, the medical evidence is the necessary and the essential one. So in order to get the evidence medically, he has to be submitted before the medical examination. So the arrested person should be taken to the hospital and examined by a government doctor. The next procedure is to submit the reports to the district magistrates. A police officer, after making an arrest and after following these procedures, should send a detailed report to the district magistrate. The district magistrate will take care of all the procedures, whether the procedures have been maintained or not. Even a little bit of procedure has been violated, then the arrested person may gain confidence. So the detailed report should be submitted by the police officer to the district magistrate. And the last one is the police officer should not discharge any arrested person without a bond or bail. The arrested person can apply for a bail before the court. If the court grants a bail, then only the police officer should relieve him. Otherwise, the police officer cannot relieve the arrested persons. Until further orders, he has to detain the arrested person in his custody. Next, we will move on to the rights to the arrested persons. Why the rights have been conferred on the arrested persons? By our Indian Constitution itself, there are fundamental rights which have been conferred on each and every citizen. Even the arrested persons also have some rights. We are going to see what are the rights one by one. The number one is right to know the grounds of arrest. For example, if a person is arrested by a police officer, but the arrested person should know for what reason he has been arrested. Because without reason, no one can arrest any person. No one has the liberty to take another own liberty. So the grounds of arrest, what are the causes, what are the reasons, why he has been arrested, what is the offense, what are the charges, everything should be informed by the police officer to the arrested persons. That is the first right conferred on the arrested persons. The number 2 is the right to inform about the bail. If it is a bailable offense, then the police officer has to inform the arrested person that he may be released on bail. He can take any steps to approach the court to get the bail. The next right is to produce the arrested person before a magistrate without a delay. The warrant has been issued by the magistrate and the police officer is implementing the order. After implementing the order, he has to submit the arrested person before the magistrate immediately without any delay. If any delay is inordinately caused by the police officer, then the court will question the activities of the police officer. No police officer can detain any arrested person after 24 hours. He has to produce the arrested person before the magistrate within 24 hours. Even if it is mentioned in the warrant, he has to submit the arrested person before the magistrate within 24 hours. The next right is the right to get a legal practitioner by the arrested person. An arrested person can contact his legal advisor, he can call his advocate, he can give some ideas and some suggestions for his bail or bond. So the arrested person should be given the right to call his legal advisor. That is the essential and necessary right conferred on the arrested persons. The next right is free legal aid. If an arrested person does not have any capability to consult a lawyer or get a lawyer, he can be provided a free lawyer from the court. The court will decide the matter and give legal assistance freely to the arrested persons. So the arrested person should be informed. Even though they are not able to engage a lawyer, they can get a lawyer or advocate from a government side. The government will provide all the necessary assistance to the arrested persons if they are poor people. The next right is the right to be examined by a medical practitioner. Arrested persons should be examined by a medical doctor in order to know whether he has any disease or any other things related with that. If the persons arrested, sometimes they may fall to death even in the custody. At that time, the charge will go on the police officer. In order to avoid this, the police officer immediately after arresting the persons should make for medical examination. If he is thoroughly examined by a medical doctor, then it can be utilized by the police officer when something happens errorly. The last right is the transparency in the police and the arrested person's relations. What is the relation between the arrested person and the police officer? The police officer is a public officer and the arrested person is an accused. That is the relation between the two. But if a police officer arrests a person with a personal motive, then it will not be fruitful for the conducting of the inquiry. At that time, the court will interfere in the matters and see whether there is any transparency between the accused and the police officer relations. It should be only of public cause and not of personal cause. So far we have discussed what are the procedures for making an arrest and what are the procedures after making an arrest. So we have seen what is the meaning and purpose of arrest, who has the decision to make the arrest, and who are involved in this arrest, who has the authority to arrest, and what are the powers to them. So far we have seen all these matters. Every day so many arrests are made, and today you know all the procedures about making arrest and after making arrest, what the police officer has to do. So as a general or a specific one, you know all the procedures relating to arrest. But the Supreme Court has laid down so many guidelines regarding arrest. The Supreme Court has given weightage to the fundamental rights of the arrested persons. The Supreme Court consider the arrested persons as also the citizens and they have the rights. So many rights which have not been conferred by the Criminal Procedure Code have been given by the Supreme Court. The judges have taken into consideration the rights of the arrested persons and they have come out with so many guidelines. We will see some of the guidelines. For example, a person who has been arrested, when he is brought to the court, he should not be brought to the court with handcuffing. He should be brought on a free manner. And during inquiry, the police officers should not harass him. The physical harassment is mostly avoided. With these observations, I conclude my lecture. I hope this will be very interesting to you. Thank you for your participation.